Welcome to the DC Bar Labor and Employment Law Community, the Federal Bar Association, DC chapter, and the Metropolitan Washington Employment Lawyers Association's May webinar. That's what friends are for, effective amici in employment appeals. I'm Scott Oswald, and MWELA's Bench Bar Committee Chair and your moderator for today's program. Before we begin, Rosie, Romano, and Jonathan Lasken from the DC Bar Labor and Employment Community and the Federal Bar Association DC chapter are here to tell us a little bit about their organizations. First, we're going to hear from Rosie Romano. Rosie.
Great. Thank you, Scott. Thank you all for having me today. As Scott mentioned, I'm the chair of the DC Bar Labor and Employment Law Community Steering Committee, and we are thrilled to co-sponsor today's event. I wanted to extend a big thank you to Andrew, who is spending today with a new addition to his family, and Scott and our panelists for all their work in putting this together. For those of you that are not familiar, the DC Bar Labor and Employment Law Community is a practice-specific group designed to increase engagement and collaboration among DC labor and employment lawyers from all practice settings, including plaintiff side, defense side, government, and in-house counsel. And since we're in DC Bar renewal season, I will make a brief plug to join the labor and employment law community when you're renewing your bar license this spring. You'll gain free access to most of our events and become eligible to run for a seat on the steering committee next year. We're always looking for folks who are interested in leading the community and organizing great events like this one. So I encourage you to give it some thought. And with that, I'll turn it back over to Scott. Thank you again for having us.
Rosie, thank you. And now to Jonathan Lasken. Jonathan?
Thank you, Scott. Good morning, everyone. I am the president of the DC chapter of the Federal Bar, and I want to echo the thanks to MWELA for getting us involved, and to Scott and the panelists for putting all of this together, and to thank everyone for being here today. The DC chapter of the Federal Bar Association is really excited to be co-sponsoring this event, and I'm excited to briefly introduce us. The Federal Bar Association is a national organization of lawyers who practice before the various federal courts, agencies, and boards across the country, as well as the lawyers who make up those same federal courts and agencies and boards. The DC chapter is the local chapter of the Federal Bar Association. We're devoted to advocating for the federal court system and federal practice in general, and our focus is on programs and other issues that further federal practice. And we have two upcoming programs that are examples of that I'll mention. On May 22nd, we have our yearly afternoon program that focuses on modern issues in government investigation. And on June 1st, working with the DC Bar litigation community, we have an event featuring Judge Pan. So we'd be very excited for you if you decided to join with us, if you're a federal practitioner. And beyond that, I just want to say thank you to Scott and MWELA for the opportunity and for getting us involved. And I will turn it back over to Scott for this exciting program. Thank you.
Jonathan, thank you. And now to our participants in today's roundtable. The Honorable Gregory Katsas is a judge on the United States Court of Appeals for the DC Circuit. Before joining the court, Judge Katsas served as an Assistant Attorney General for the Civil Division at the United States Department of Justice. Judge Katsas also served as Deputy Counsel to the then President of the United States. Jennifer Goldstein is the Associate General Counsel at the Equal Employment Opportunity Commission, where she leads the Office of General Counsel's Appellate Litigation Division. In that role, Jennifer oversees the filing of commission party and amicus briefs in the United States Courts of Appeals on a range of employment discrimination issues arising under federal law. John Masslon is a senior litigation counsel at the Washington Legal Foundation. Each year, John files over 30 amicus briefs in cases before the Supreme Court of the United States, federal courts of appeals, and state courts of last resort. Finally, Lindsay Nako is the director of litigation and training at the Impact Fund. Lindsay has authored dozens of amicus briefs for the Impact Fund. I'll take at least some of your questions throughout our discussion. During today's program, just use the Q&A button located at the bottom of your Zoom screen. Let's get it kicked off with Judge Katsas. Judge Katsas, let's just talk about the function of amicus briefs. Give us a sense of, for you and the court, the function of amicus briefs in the controversy that's before you.
Sure. Thanks, Scott. The most helpful amicus briefs are ones that will more fully develop an issue or an aspect of a case that, for whatever reason, the parties haven't addressed as thoroughly or completely as the amicus can. You might have a situation where an amicus can do a deep dive into the history behind a provision or a deep dive into the practical consequences of a decision. You might have cases where the facts are very complicated, or there are 10 different legal issues in the case, and one of them is very important, and the party only has a limited number of pages, and the amicus can develop that much more fully. The general point is there's some important discrete aspect in the case that the amicus can develop much more fully than the parties have been able to.
Are there times that you've seen where the merits brief for the parties maybe just doesn't hit the mark, but the amicus really does for you?
Yeah, I mean, party briefs, some are very good, some are not so good. So it can be as simple as the amicus just does a better job on the question presented than the party. But I would say more often it's the party is doing a fine job on the basics of the case, the facts of the case, the relevant precedents, and the amicus is taking a deeper dive on some specific aspect of history or consequences or something at the periphery that we need to know about for some reason.
Let's talk about public policy for a minute. Is it helpful when Amici kind of highlight the legal, maybe economic or social implications of a particular outcome?
Yes. I consider myself a traditional textually oriented judge. I'm going to start by trying to figure out what the statute means and what the words say. But there are lots of cases where that's a close question. And the consequences can really make a big difference in terms of, one interpretation seems to make the words all fit together and make sense, and another one produces consequences that seem very strange. That's certainly something that almost any judge would take into account, even ones like me who would self-describe as textualists.
Judge Katsas, thank you. I'd like to turn to Jennifer at this point. Can you introduce us to your office and how your office kind of approaches its amicus work at the EEOC?
We handle all the amicus work for the whole country, and we file mostly in the U.S. Courts of Appeals, but on occasion in district court, or even we filed one with the NLRB. We're very eager to file amicus briefs. We do a lot. We do about, 25 a year maybe. And what we're looking for are ways where we can be helpful, frankly. Typically, maybe developing the law, because we obviously we enforce, we administer, and on occasion we're actually talking about our own regulations where we have authority to issue regulations. So that's, and I think we take very seriously, especially when we're talking about procedural regulations and how courts are construing the administrative process. That's very important to us, but we do a lot on substantive legal issues as well.
Judge Katsas, back to you just for a minute. Let's just talk about the government as the author of an amicus brief. How do you feel about a government agency weighing in on, let's say, a statutory scheme on which they have enforcement authority like the EEOC?
I think it's very helpful. I oversaw a lot of that when I was head of the civil division. We filed a lot of those briefs. The federal agencies tend to have very good lawyers and a very high degree of professionalism and a very high degree of expertise. So if we get something from the EEOC, it's probably going to be pretty helpful to us.
Thank you. Jennifer, back to you for a minute. Let's talk about the institutional interests in filing amicus briefs. When you think about the EEOC's institutional interests, give us a sense of that thought process and the kinds of things that you're looking at really to get involved in.
It's a hugely wide range of things. I mean, starting with, I was looking at some of the amicus briefs we filed in the last year or two. We filed on the validity of our regulation about issuing early right to sue notices, which I think probably a lot of the listeners are very familiar with. So we're very interested in the procedures. We filed briefs on, is it 180 days or 300 days to file a charge, which I still can't believe after all these years, we're still having to explain to courts. But we also file on substantive legal issues. For example, we did one on our damages available for ADA retaliation claims, which is involves a very intricate statutory analysis. And we're interested in more general issues that are relevant to us when we go into court. For example, Iqbal Twombly, and when courts dismiss complaints we think improperly, we've come in on a lot of cases where that's the main issue. So it's our administering the statute aspect that we're interested in. It's the substantive interpretation of statutes, and then it's also our ability as plaintiff to ensure that we think that courts are applying, that are getting it right.
Judge Katsas, back to you for a minute. Let's just talk about other kind of interested government parties, such as, let's say, senators writing an amicus brief on a particular topic. Helpful?
Sometimes. Depends on the quality of the brief. I will say there are times when we get briefs from senators or members of the House where it seems like the primary purpose of the brief is not to add something new and helpful, but to just associate the filers with one position or another that's politically helpful to them. And it's perfectly fine. That's their prerogative. If we get a brief like that, it is not hugely helpful to us. But if we get a brief from senators that's well done, I mean, we certainly won't count that against them. So it really depends on the quality of the individual brief.
How about from the states as an example? States attorneys general weighing in on particular topics.
Yeah, there's some cases where states have programmatic interests and expertise, and their filings are a lot like the filings of the federal government, where they have programmatic expertise and interests, and those tend to be pretty helpful. You can imagine cases with federalism interests and, I don't know, a question about whether the EEOC or a state EEOC has authority over a certain kind of question, and the feds are on one side and the states come in on the other side. That's likely to be pretty helpful. There are some other cases where states are coming in just sort of more like the typical senator's brief, where a case has a political valence and red states want to be on one side and blue states want to be on the other. And those on average tend to be less helpful. But again, it just really depends on the quality of the individual brief.
Thank you. Lindsay, I'd like to bring you into our conversation at this point. Can you introduce us to the Impact Fund and your amicus program?
Of course. Thanks so much, Scott. The Impact Fund is a nonprofit legal organization. We are located out in Berkeley, California. So I'm just starting my day out here on the West Coast. We were founded over 30 years ago, initially as a grant-making organization to provide grants and support of litigation that is seeking environmental, economic, racial, and social justice. We also have an active litigation program, which I run, as well as a training program to provide practical skills trainings, particularly in the area of impact and class action litigation for public interest attorneys. So for us, our amicus program is a really critical part of our advocacy. We represent parties in court, but the amicus also serves an incredibly important function of letting courts across the country know when they are hearing a case that may have a potentially unknown or unseen impact on underserved, under-resourced communities. So it really is an element of access to the court system for folks who, have been historically shut out in a lot of ways. So when we can write and let courts know that a legal ruling may have an impact, whether positive or negative, on a group that is not, a party before the court, that is a really valuable part of our advocacy.
Lindsay, thank you. John, I'd like to turn to you to tell us a little bit about the Washington Legal Foundation and its amicus program.
Sure. Washington Legal Foundation is a nonprofit law firm and policy center based in Washington, D.C. We advance free enterprise ideals and also publish papers on those ideals. Our amicus program, we file about 60 amicus briefs a year. I think last year we filed 66 amicus briefs, mainly in the Supreme Court of the United States and federal courts of appeals, but also in state courts of last resort.
Thank you. Jennifer, turning back to you for a moment, how often does the EEOC pair up with other government agencies? Let's take the Department of Justice first. How often does that happen? In an amicus, let's say writing an amicus brief.
Yeah, pretty often, especially where it's a case involving a state and local government under Title VII or the ADA, where DOJ has the primary litigating authority. So we did it in the Chambers case, for example, which is, I think, went en banc to the DC Circuit. DOJ took the lead in that one because it was against the DC government. We don't pair up too often in private sector where the employer's a private sector employer, but in governmental cases, we do it, I don't know, maybe 5 times a year, mostly with the Civil Rights Division. It's occasionally over the years, we've paired up with the Department of Labor, and that's probably it.
Thank you. You mentioned before where the EEOC is filing amicus briefs. Does the EEOC file amicus briefs in district court?
Yeah, I think that we don't do it. There's a practical problem, frankly, with filing in district court, which is that it's hard to find out about these cases in time to file an amicus brief. It's much easier to find out about cases that are in the Court of Appeals. And obviously, there's more bang for your buck when you're filing in the Court of Appeals because you may set precedent. But we did I would say people should not be shy about contacting us, especially if they can give us heads up far in advance about a district court case, where there's a important legal issue that's really cutting edge. We did a fair number of cases prior to Bostock involving the issues that ultimately got decided there. I personally feel it's important for us to try to get involved in district court if we made a mistake, like in the investigative process. I think it behooves us to try to get involved and explain to the district court that EEOC's mistakes shouldn't penalize the individual. And I would say actually the third category where I would be interested is also procedural, early right to sue cases. It's so hard to challenge to address that issue in the courts of appeals because most plaintiffs' attorneys figure I'll just wait until it's 180 days. I assume I'm talking as if people are familiar with this issue. So it's pretty rare that it gets to the Court of Appeals, but we'd be very interested in addressing that sort of issue, for example, in district court.
Thank you. Lindsay, coming back to you for a moment, give us a sense of the process and consideration when you're thinking about, let's say, district court versus an appellate court or even the Supreme Court. Is it different at the impact fund?
Is procedurally, it can, in addition to all of the things that Jennifer just said about filing in district court, it can also be hard to file in district court. They're often procedurally not set up for amicus briefs in the same way as amicus briefs are written into the rules for courts of appeal. So, we have filed in state district courts and state trial courts and in federal district courts. But now my personal preference is to do that where the parties have written amicus briefs into the scheduling order, indicating that the presiding judge is aware that amicus briefs may be filed and has approved them and is interested in receiving them. We also have to then think carefully about our role as amici, because the trial court level is the fact finder. So we have to be a little more thoughtful about what facts we're putting into the record, how we're affecting, what the judge wants to see from us. I think we have to play something of a more narrow role in the trial court, just to make sure that we're not potentially viewed as trying to manipulate the evidentiary record. But it can be really useful, especially when we're talking about motions for preliminary injunction or other critical motions that could be determinative in a case and really will have an impact on the community that we're representing as amici. So we will consider it, but I think about it more carefully. I think the road to filing an amicus brief in the courts of appeals is much more well-trod and predictable.
Thank you. John, how about at the Washington Legal Foundation? Is the process the same or different for district court, appellate court, Supreme Court? How does that work in your shop?
I mean, I agree with everything that Lindsay and Jennifer said. It's a lot easier to file in the appellate courts than the Supreme Court. So typically that is where we focus our filing attention. I've been here for 2.5 years and we've only filed 2 briefs in the district court during that time, and over 120 in the courts of appeals and Supreme Court, not only because of the precedential value and the bang for your buck you get at the appellate level, but also trying to find local counsel in many districts is very tough. And as Lindsay said, a lot of them don't have local rules contemplating amicus filings. So one of the briefs we did file was in the District of Columbia, and that's because the local rules in DC do contemplate amicus briefs. And so there's kind of a pathway there where there aren't in most district courts.
John, thank you. Jennifer, let's talk about the Supreme Court. Is the process different for the Supreme Court when the EEOC is considering weighing in?
Completely different. Yeah. By our statute, the Solicitor General represents us in the Supreme Court. So our role is to urge the Solicitor General to, to file, if there's an amicus possibility, to file advancing the arguments we think make sense to advance. So, and that's a pretty well-established process over there. They typically will have party meetings allowing both sides to make their pitch, and then they'll have a whole host of parts of the government attend so that they can kind of express what interests they have and what position they think the SG should advance.
Jennifer, let's dive in just a few of the issues that you touched on that the EEOC has been interested in the past. Let's talk about first the standard for summary judgment. Is that something the EEOC is interested in?
Of course, because it comes up so often. I feel like we have filed briefs talking about Iqbal Twombly, those Supreme Court decisions more explicitly in briefs, but we will say, for example, to the extent that courts are sort of misunderstanding the a possible causation standard or pretext, and how to evaluate pretext evidence on summary judgment, we do file. We're not really interested in getting too deep into, making too much of a fact. We're more interested in making a legal argument than a really deeply fact-based argument. But often, of course, they intertwine, when you're talking about pretext or harassment, or there's no getting away from the facts.
So the Chambers case dealt with what constitutes an adverse action under current precedent. What attracted the EEOC to that case?
Well, that's been a huge issue. We actually, with the Department of Justice and on our own, we have filed a lot of issues, a lot of briefs, amicus briefs on that issue. And in fact, the Supreme Court recently invited the Solicitor General to address whether it should grant cert in two cases, Muldrow and Davis, one involving lateral transfer or reassignment, and one involving paid suspension, whether that's an adverse action. That issue comes up. I mean, if you did a Westlaw search and put in the term purely lateral transfer, just as an example, you would get a lot of cases. It's just an issue in so many cases. You know, does this count? And so it's important for us when we litigate. It's just important generally in the law.
Another issue the EEOC has been interested in is causation, and in particular, what but-for causation means in employment cases. And you mentioned Bostock earlier, which defines the standard as a but-for causation standard. Is this something the EEOC is interested in prospectively?
Oh yeah, we filed a lot of briefs on that, explaining, for example, that but-for cause doesn't mean sole cause. Talking a little bit about motivating factor. Yeah, I think the Bostock opinion is helpful in explaining how to think about what but-for cause means. But it's definitely been an area of some confusion. I think some courts, the Supreme Court has alternated, sometimes saying a determinative factor, this is in a different context, or the determinative factor, and what does that mean? How do you think about that when the employer has an explanation? So yes, that's definitely something we've filed, we've addressed a lot.
How about under the Americans with Disabilities Act? Is the EEOC interested in cases under the Americans with Disabilities Act?
Oh, very interested. There we've said a lot in. We have the authority to issue regs substantively and procedurally. We do a lot on, and Congress amended the statute in 2008, and that amendment seems to have escaped. Unfortunately, a lot of it doesn't get addressed properly too often. So we do file a fair number of just error correction briefs where neither party addressed the ADAAA, and so the district court ended up relying on outdated law or outdated regulations. So that's very important to us. And it's just, there are a lot of hard issues under the ADA. There's some easier issues. I think the ADAAA was meant to make the disability assessment easier, but there's still tricky issues. You know, leave as a reasonable accommodation, reassignment as a reasonable accommodation. Even in some disability issues, we filed a brief recently on alcoholism as a disability. So I think there's a lot there that these issues are hard. So I think we are very interested in the ADA.
Lindsay, I saw you nodding your head as Jennifer was talking. Give us a sense of some of the issues that, and in particular employment law issues, that the Impact Fund has been interested in and weighed in over the last few years.
We're a shop of procedural nerds. So we love procedural issues, primarily around Rule 23, class and collective actions under Title VII, FLISA. We are very interested in the use of collective and group litigation to ensure that, you know, in particular, low-wage workers are able to band together and have their interests represented in court together. So interpretations of Rule 23 are something that we write on a lot. We have also written on the disparate impact standard under Title VII a lot. Standing issues. There are always new standing questions being posed. And so I write a lot on standing. All of the ways that the doors to the court, access to justice can kind of slowly be closed to people who have less of a voice in the judicial system. We want to try and keep that door as wide open as possible. So those are just some of the issues that we write on.
What are maybe some of the issues you see on the horizon that might be coming down the pike that we maybe should be attuned to?
I absolutely think standing is a conversation that we're all having right now, especially after Ramirez versus TransUnion. The question of what is a concrete harm. There is a lot of incentive on the other side of the V to try to interpret that very narrowly, because if someone can't get into court, then does it even really matter if the defendant has violated the law or not? So I think we are seeing an increase in deliberation over what concrete harm means and what standing means, and whether whether statutory violations are sufficient to create standing. And so that's something that I'm definitely keeping an eye on in the horizon.
Lindsay, talk to us about building a coalition. Those that might be interested in joining a brief that you're writing or banding together to write a brief. How do you go about that process?
First and foremost, we're looking at the issue and what we think is going to be helpful to the court. The court is our audience. The judges and clerks who are going to be reading our brief are always at the forefront of our minds. So we're trying to think about what is the coalition of voices that is going to be able to, one, have the requisite interest, and two, that are going to carry credibility with the court. So if we're talking about, for example, interpretation of a state law, a nationwide coalition may not be the most useful set of voices. A judge may be more interested in the folks who are invested in the passage and enforcement of that state law, the organizations from within that state that are serving people who are going to be impacted by the interpretation of that law. In the Supreme Court, we want to avoid duplicative briefing. So if there's a big issue that has a nationwide impact, we might think more about how many folks can we get onto a brief that all share the same interest and the same perspective, so that we can avoid a multitude of briefs just inundating the courts. So those are some of the things that we think of. There are a lot of organizations that write just for themselves. We do that less often. We think we're better in coalition. And so we often will partner with groups either geographically or based on subject matter that represent the interests of the communities that we're trying to give voice to. And then we're always thinking about who's going to be reading the brief and what is going to be helpful to them. What are they going to care about? And, how can we present that in the most efficient, effective way possible?
Jennifer, back to you. From your perspective and the EEOC's perspective, what are some of the employment law issues likely to be on the horizon in the future that the EEOC is going to be looking at?
I would say that where there might be some new, the same old issues, I think will continue to arise, but I think some of the new issues may flow from whatever the Supreme Court ends up deciding in Groff versus UPS, which involves the standard for undue hardship for religious accommodation claims. The Pregnant Workers Fairness Act, which goes into effect in late June, I would think, will be, and we've been authorized to issue substantive regulations under that law. That should create some interesting new issues. I don't know if COVID will. I personally haven't seen that many COVID cases come to us for potential amicus briefs. So I don't know if that's going to be, it's something we're interested in. We've put out a lot of guidance on that issue, but I don't know how much litigating we'll do in that area. And then if the adverse action, employment action issue goes up to the Supreme Court, if they take that pair of cases, that will be very interesting.
John, over to you. Employment issues bubbling up in the courts on which the Washington Legal Foundation might be interested.
On the substantive level, I think number one is the scope of the transportation workers exception to the FAA, especially after the Supreme Court's decision in the Southwest Airlines case, and how courts are going to apply that moving forward. Another issue is California's AB 5 and other states' attempts at classifying workers as employees instead of independent contractors. And along with the NLRB is getting involved in that in the Atlanta Opera case, and you see some other action at the federal level as well. And then finally, you have the joint employer rule and who is considered a joint employer for FLSA purposes. I think all of those are important substantive issues. And as Lindsay mentioned, on the procedural level, I do agree with her that the action is at the Rule 23 and at the standing level. We filed a brief on the prevailing side in TransUnion, and we continue to file briefs in the federal courts of appeals, arguing that uninjured plaintiffs lack standing to file suit in federal court because there's no case or controversy there. And then we're also trying to prevent individuals from banding together when their claims are dissimilar and forcing companies into settling cases just because of the risk of ruin rather than actual meritorious claims.
John, thank you. Lindsay, back to you for a moment. Let's talk about the hallmarks of a good amicus brief from your perspective, and in particular, kind of knowing your audience. Why is it important as an amicus brief writer to know your audience?
Well, I was heartened to hear a lot of the things that I think about amicus briefs from Judge Katsas. That always feels good. I think the hallmarks of a good amicus brief is when you have an interest and an expertise that is relevant to the case, but is not going to be part of the party briefing. Or is going to be a very small part of the party briefing. I feel very strongly that, Me Too briefs are not helpful. We try to think very carefully about what is the party going to say, and then what can we say that's, that is what is our interest that is not going to be thoroughly covered in the party briefs. So we want to be additive. We also want to think about who else might be writing and whether there's going to any potential duplication between amicus briefs, because we don't want that either. We want each, ideally, one amicus brief or each amicus brief to cover a different area. And so sometimes that is, defined, like I said before, by geography or what our particular subject matter expertise is. And it is sometimes those historical briefs that Judge Katz has referenced, those can be so interesting and fun to write, to go back and do deep dives into the legislative and political history of some of our civil rights laws, to really talk about why do they exist, what is their purpose, what is their historical relevance, and what is their modern relevance. That's usually, it's not something I can cover in my briefs when I'm party counsel, using valuable pages to go back to the dusty tomes. But I really do love the opportunity to do that as an amicus, to really spend some time, deep in the history books. And then also Judge Katz's earlier reference talking about the practical consequences of rulings. So for us to be able to say we are representing low-income workers, we are representing workers with disabilities, and the implication of this case, whether or not it's even an employment case or whether or not it's a case that is, where one of the parties is reflective of the group that we're representing, but to say, the outcome of this case could have a very direct and significant impact on this community of workers is, I think can be really valuable. We do try to always keep it brief. We always mind our page limits. We know that judges across the country are taxed, And so we are trying to make our point as quickly as we can, and then get out in hopes that as many people will read our briefs as possible.
Are there courts in which you might be less likely to file an amicus brief than others?
Well, yeah, I mean, we're always thinking about whether our voice is going to be helpful. So as a politically progressive organization, there are probably some courts where a brief from us might be more of a red flag than a green flag. So we do think about that. We in the early days, we will have a coordinating call with party counsel, in part to say, here's what we want to write on. And then, and we also want to know whether or not they think we will be helpful in a case. And if a party says, we really don't know, we're unsure, or we don't think it would be helpful to have the communities that you represent, then in the case, we think about that really carefully. Because at the end of the day, we're not party counsel. We're not in the courtroom representing clients. So we definitely take that into consideration.
Are your goals different in a class case than in an individual case as the amicus coming in?
Well, we are only looking at cases if we think that there is a potential for a systemic impact, which is part of why we do most of our work in the courts of appeal. So we are unlikely, just because our focus is on class and impact litigation and using litigation for systemic change, we are unlikely to come into a case, particularly, for example, in the trial court where it's an individual plaintiff who has, a case with a set of facts that's very individualized to them. We're pretty unlikely to do that. If we are coming in, it's because there's some principle that is being examined that could have widespread effects, either that, the widening or the closing of the courthouse doors is what we're really looking at. So those are some of our thoughts. If it is an individual plaintiff, I'm going to look pretty hard at it, because my job, first and foremost, is to stay within my organizational mission. I like my job and I want to keep it. So and we have such limited resources, right? I think all of us would agree on this panel. We have really limited resources. So we have to think carefully about how we use those resources. And so I think that those are a lot of the things that I think about.
Judge Katsas, let's talk about the hallmarks of a good amicus brief. The brief itself. What are the hallmarks of a good amicus brief, both in form and substance?
I would say short is better than long. Focused is better than scattershot. Additive is better than repetitive relative to what the parties are saying. And consolidated is better than, one brief with 4 or 5 organizations with similar interests is better than 4 or 5 briefs from those organizations. I'm basically underscoring everything that Lindsay said, and I'll just do that by asking you all to consider this from the perspective of your audience, which is the judges. I have to sift through 9 cases a month on average, with most of which have a high degree of difficulty. A lot of my colleagues on regional courts of appeals are probably doing 2 or 3 times that many cases, right? We have to do a lot of reading and plow through a lot of stuff. So if the brief looks distinctive and helpful and is easily digested, that's more likely to have an impact than if we're getting a dozen similar briefs that read like a summary of argument of the principal merits brief.
Give us a sense of maybe the top 2 mistakes that you see Amici make in the briefs that they file before you.
I think it's pretty much what I just said. We get a lot of briefs well, we get some briefs that read like summaries of argument of the parties, or, are sort of more obviously political. As I said, those are mistakes. If your goal is to move the needle with the court, that's a mistake. I get the point. A lot of organizations are filing these briefs for other purposes, right? For fundraising or whatever. And it might be helpful for those purposes to toss in a 5-page brief that doesn't consume a lot of resources and identifies the group with the outcome. That's fine for the group. It's not helpful for us.
Volume of amicus briefs. How much attention do you pay to the volume of amicus briefs that come in on a case, Judge Katsas?
It's something I might notice. I would say quality, the quality of the briefs and the credibility of the organizations that are before us are probably more important than the sheer number of briefs. But if we see a case with 5 or 10 amicus briefs, that's a little unusual, and it's something I would notice.
Let's talk about the mechanics for a moment. The motion for leave to file. How often generally are motions for leave to file an amicus brief denied at the DC Circuit?
Almost never.
Are there any reasons why something might be denied?
If the motion's filed out of time, if there's something about the group that looks squirrely, I don't know. I would say most of my colleagues and most other courts are pretty generous with granting leave. So we don't deny very often. We
Lindsay,
might take a brief that's unlikely to be helpful and toss it to the side, but we'll let people file almost always.
So Lindsay, the life cycle of briefing on appeal, talk to us about just the mechanics of that. When do you file your amicus brief, and does it depend on which side you are supporting, if you are supporting one side?
Well, first thing always is, we go back to the rules, and we want to make sure we have a full understanding of, every time I still reread the FRAP, and then you go to the circuit that you're going to be filing in, and you want to reread all of those rules. When the Supreme Court, I think it was back in 2019 now, put out their memo on amicus briefs, I was like, oh, that was bedtime reading. I loved it. So the first thing we want to do is we really want to know, what is the court expecting from us? What are the rules? And so that'll tell us, of course, what our deadline is. When we get started, in a perfect world, which, as we know, it often is not, but in a perfect world, I will have 5 or 6 weeks notice or more on a brief, more possible in the courts of appeals. So to have plenty of lead time to know about it. Oftentimes we will get, cold calls from attorneys around the country who say, we have an issue we think that's come up on appeal. We think it is in your wheelhouse. Is it something that you would be interested in weighing in on? So I like to have time to sit with the decision that's up on review, and then any other of the relevant briefs that are available. If any party briefs have been filed, I like to have time to sit with those. And then we'll start thinking about, what is our issue, what is squarely within our interest, and what is the coalition that we think will be most effective to pull together to really bring that home. And so then it's, about 4 weeks out, we'll send out our save the date, to groups that we think might be interested in joining us, letting them know, hey, this case is coming up in the pipeline, and here's what it's about. Here's what we're thinking of writing on. And then we will write our brief. Sometimes we write by ourselves. Sometimes we write in partnership with other organizations. And then we'll send a near final brief out for circulation, usually about 2 weeks before the brief is due, so folks have time to sit with it. The people that we partner with a lot, I'm familiar with their approval processes. Some people can do it very quickly. Some people have very formal, some organizations have more formal processes that might take a few days to get approval. And so we want to make sure that everyone has space to go through whatever their internal process is for review and evaluation. And then we want to, have all our amici on board, hopefully about a week out from filing, so we can polish up that brief and, not give our paralegals heart failure and give them plenty of time to do their jobs, and then get it ready and get it filed. The timeline is different in the Supreme Court because we have to bring on board the printers. And so we have to remember to build in extra time for that to make sure that we can get our brief to the printer in time for them to do all the, incredible typesetting and beautiful binding that they do. I would say to the folks out there who are thinking about bringing amici into some of their cases, it's really never too early. I have briefs that are sort of on my mental to-do list that won't be due until late summer, early fall. It's never too soon to give folks a heads up if you're trying to get amici onto your cases.
Judge Katsas, we have a question from the audience. Can Judge Katsas address how he and other judges think about oppositions to motions for leave?
I don't think much of oppositions. As I said, we grant almost routinely. I would say most sophisticated counsel consent to amicus filings because A, it's likely to be granted, and B, it might come off as a little defensive, if not petty, to try to keep amici out. So unless there's some really odd feature of the case or the amicus, I would not recommend spending a lot of time opposing a motion for leave to file.
Jennifer, let's talk about the process that the EEOC goes through in deciding whether to file an amicus brief in a particular case.
Yeah, it's somewhat elaborate, which is why knowing in advance is helpful. We have our own internal, do we think this is a good amicus vehicle? The line attorney will start to work on a memo if that attorney and the supervisor agree. It then goes up to me, and then it goes to the general counsel. This is the recommendation memo. And then once the general counsel agrees to recommend amicus participation, it has to go to the full commission for a vote to approve or disapprove the general counsel's recommendation. And it's not a foregone conclusion that they will consent. They've for the most part, they do approve our recommendations, but if you look on our website has a list of commission votes, and you'll see periodically they voted it down. So we think about, so that's our process, and so and I hope, I think that means that judges, aware of that process, understand all the hoops that government amicus briefs have to go through before they get filed. And I hope that they, read them accordingly.
We do.
Jennifer, just mechanically, how do you hear about cases that you might want to file an amicus in?
Yeah, it's actually relatively rare that people contact us directly, and we have a dedicated email, amicus@eeoc.gov. But for the most part, either we'll see in news clips, or most frequently, we have a system in which every week we look at cases where a notice of appeal has been filed, and certain codes. The clerk's office will put certain codes on each case. So we do searches based on those codes, and we'll just look at the underlying district court opinion and see if we think there's a good issue there.
If someone in our audience, let's say, wants to have the EEOC consider filing an amicus brief, do they use the amicus@eeoc.gov address to send you a query?
Yeah, that would be helpful. Certainly, we may well have seen it already, but yeah, it's helpful to just hear about a case and then, get the docket number and get the briefing schedule and get a sense of whether the briefing schedule is likely to stay as it is, and then we sort of go from there.
In terms of getting to you early, Lindsay talked about the importance of notifying the impact fund as early as possible. Where do you come out on that?
Oh, it's just because of all those hoops we have to jump through. And it's even more complicated when we're partnering with the Department of Justice, because we have our hoops and then they have their own separate hoops, which entail, when it's in the Court of Appeals level, getting the division approval and then going to the Solicitor General and getting the Solicitor General's approval, and then typically other divisions. So the civil division, if civil rights proposes an amicus filing, the civil division, for example, will also weigh in and explain what their thoughts are. And then at the end of the day, the SG makes that decision. So yeah, it takes time. And it's helpful when we know early and we can, so that we can just get that process started.
Lindsay, turning to you, just mechanically, what's the process of notifying the impact fund that someone might have an issue that the impact fund might want to weigh in on?
People are welcome to contact me. I'm just lnako@impactfund.org. Yep, that's right. I just put that out there. We are a small shop, but we love writing amicus briefs, and we file them all over the country. So our internal process is pretty straightforward. Our legal team will get together and confer. I'll run it past our executive director. It's pretty straight, and then as long as for us, it's mission aligned, we have an interest, it makes sense for us to be writing on it. We think we have the subject matter expertise to write proficiently, and, it's an issue that we care about. It's, and as long as we have the capacity to do it, we are totally game, or we're happy to also refer folks to other groups that we know have actus amicus practices that have different subject matter expertise that might be a better fit for the case. I know there are some organizations that also have steps where they go through their executive leadership, but also a board of directors. Sometimes a nonprofit board may have an amicus committee that reviews and weighs in. So that's why ours can be pretty straightforward, but for reaching out to other nonprofits, I would still say, it's never a bad idea to give as much time as possible.
John, and if someone wants to contact WLF about considering filing an amicus, what's the process with your shop?
So they would send us an amicus memo that sets forth the details of the case, kind of what they're looking for in an amicus brief, the due date, all the relevant facts. They would send that either to myself or to our general counsel. We'd take a look at it, and we do have a litigation review board that then makes the final determination based upon our recommendations and their own input on whether to file in a case or not. And that deals with a lot of what's the procedure of the case, what's the issue, how important is it, timing, how much notice we have, those all play a role.
John, how do you learn about cases apart from interested parties contacting you directly? How do you learn about cases that you might want to file an amicus brief in?
Well, I look at all the petitions that are being filed in the U.S. Supreme Court, obviously all the grants that are there, and then just reading the news and seeing what's happening in the courts of appeals. If get a news alert about an interesting district court decision, might set a PACER alert to email me, and so I can follow the case and then know when notice of appeal is filed and then follow it at the Court of Appeals level. I'd say probably over 80% of the cases that we file in, either a party or the party's counsel comes to us.
Do the identities of the parties matter to you, John?
They matter in so much as, are the parties going to be easy or difficult to work with? There are some parties that are very difficult. Their in-house counsel are to work with, and that's just going to make us less likely to file. then if your in-house counsel is much easier to work with. Also kind of just like, are you in an industry that we have a lot of knowledge about? For example, we do a lot of pharmaceutical and tobacco filings. So if you're in one of those industries, we have a lot of expertise there. There are other industries where we don't have as much expertise.
Lindsay, how about for the impact fund? Does the identity of the parties or the council matter to you?
Not really. I mean, the what really matters to me is whether people are coming to us to write on topics that are within the scope of our mission. So whether or not they're really looking at those procedural issues of class action, standing, we also write around attorneys' fees and things like that. So that's really what matters to me first. And so it does happen that there are, folks in the community that we know well, that know us well. So if someone contacts me, I might be more likely to respond quickly because I know that person is familiar with us. So that what they are interested in having us contribute is probably squarely within our mission. If it's someone that I've never met before, I am still very, very interested. It's just more often in those cases, I do end up referring them out just because it's not right within the mission, our mission of what our amicus priorities are. But I mean, we have worked on cases in, circuits across the country. We've been in Florida State Court, in Colorado State Court. We've been all around the country. So as long as the issue is one that's central to our mission, I'm very interested.
Jennifer, the EEOC publishes annual priorities. Does that guide in any way the types of issues on which the EEOC will weigh in on?
A little bit, perhaps not as much though, in terms of when deciding what cases to litigate. I mean, for us, there are often sub-issues that we know are sort of raging around in the courts of appeals that are not really a priority area for the agency, but we know would be very helpful for the courts to hear from us on. So, for example, the manager rule in retaliation cases, or how to assess one-time incidents in the harassment context. These are not going to be the sort of things that the agency is going to put in its priority areas, but we know courts are sort of struggling or thinking about how to address those issues. Can I add another? I'm sorry.
Please.
You didn't ask me the question about does the identity of the party matter? And so I just want to say for us, if the party is the federal government, we don't file amicus briefs. We work behind closed doors with the Department of Justice. And it sometimes works actually that we will work with the civil division, typically sometimes with the SG's office too, to adjust their arguments, but we don't fight our battles with the federal government in public, except on rare occasions.
So we're talking about federal sector type cases or cases against an agency that move into federal district court or courts of appeals. Judge Katsas, amici that support neither side. How do you feel about amici who write in support of neither side? Is it useful?
It can be. Always depends on the quality of the individual brief, but I would say as a general matter, a party that's coming in support of neither side is likely to have some sort of nuanced take on a case for its own programmatic reasons rather than just supporting an outcome for political reasons. And, other things equal, that's probably makes it likely that brief will be somewhat interesting.
Jennifer, let's talk about do's and don'ts for a moment. What are some things that parties should do? Let's say they want your support. Some things they should do and some things they shouldn't do.
Should do is just let us know and really briefly explain the issue or issues and keep us informed just give us nowadays, we don't need paper copies. We can access them. Just let us know about deadlines. Let us know about the issues they're going to raise. We've actually had to tank a brief recently because we were going to address an issue that we had discussed with plaintiffs' counsel, and then they ended up not raising it in their brief. And so amicus can't raise an issue on its own. If the party hasn't addressed it or has forfeited or waived it, then that's it. Don't file early because we can file as a matter of right 7 days after. So if you, plaintiffs' counsel, surprise us and file early, that really puts us in a bind. So those, I'd say, are the main things.
So just in the email that we would send you, Jennifer, what should be in the email requesting potentially EEOC amicus support?
And I should say, you could send it to that amicus email or to me directly, Jennifer.Goldstein. Just the name of the case, the docket number, the issue or issues you think are important, and the timing. And the brief is currently due this date, but we think we're going to get an extension, or it's going to go into mediation, so it's likely to settle or not likely. Just really practical things we can't see from just looking at the docket.
It's maybe the one thing you'd like folks to know about the EEOC's amicus program that maybe they don't.
I do think we're helpful. I mean, Judge Katsas kind of opened up with talking about trying to be helpful to the court. We had one week where we had court appeals decisions on back-to-back days where the court said the EEOC's amicus brief was very helpful. So I would like people to reach out to us more, and I think we can be even more helpful than people realize, because typically we try to participate at oral argument, and courts typically grant our motion to participate. So it's sort of you don't just get the brief from EEOC, you also get us showing up, which I hope is helpful. I think is helpful. So I think that's the main thing.
Lindsay, if parties want your support, maybe some things to do and some things not to do.
Yeah, I know I'm starting to feel like a broken record, but contact us early if possible. We do also occasionally write around Rule 23F appeals, which are appeals from grants or denials of class certification. That has a very fast turnaround. So party briefs are due 14 days. I can see John's eyebrows went right up, nodding. Yeah, you have to move really fast. The parties have 14 days from the order to get their party brief on file. FRAP is not totally clear about amicus briefs on 23F petitions, but we usually file, at least in the Ninth Circuit, 7 days after the party brief is filed, because that's the default amicus rule in the Ninth Circuit. So that's, from the day the order is issued, that's 21 days for an amicus brief. And the parties, for very good reason, are not thinking about, amici as they're jamming to get their party brief done. So if one person on the team says, hey, maybe we should have amici, it's well worth, taking 15 minutes to put an email together and shooting it out as soon as someone thinks about it. We can do it, but that's just the nature of that turnaround, is very, very fast. Yeah, I mean, I like to know what the deadlines are, what people are thinking of. It is helpful if people know about other amicus briefs we've written. They can say, we saw your standing brief in this case, and that's a really similar issue to what we're working on. I know that's a big ask. I'm not asking people to go deep into the library of our amicus briefs, but if you happen to know of a brief that we've written before on the same topic, and you can say why, or you can say why you think the issue is within our mission and why we're the right people to write on it, that's really helpful. I also, I do like to know that that folks that would like us to come in as amici on their cases do have some argument that they think is a good fit for us. That's not going to be repetitive of their brief, and it's also not going to just be a pure, cheerleading class actions brief. I do love class actions, and I do think they're of critical importance in the American legal system. But I am not we just are not going to write briefs that are just, class actions are great. That's not a brief that's very helpful to courts, just on that general principle. So we do, so if groups come to us and that's what they ask for, we, will usually say no to that, but we will dig into the case and try to figure out, what the hook is that might work for us, or if there's another organization that is better suited for that particular case. So just having some sense of our mission and trying to make sure that you're within a few rings of the bullseye is really, really helpful. Being organized, being responsive, sending us the relevant briefs, just trying to make it easy to onboard us onto the case with just what's relevant and what the issues are is really, really helpful.
Don, paint the picture for us of cooperative counsel.
First and foremost, tell us about the case as early as possible. The earlier, the better when we know about a case. That's especially true in the 23F context. So I recently filed a 23F brief in the Ninth Circuit, and counsel told us, I think it was 4 months before the class certification order came down, hey, we think we're going to get an adverse ruling here. If we do, would you be willing to file on the 23F? And so that way, the second I set up a pacer alert, the second the class certification order hit, I could get to work. And our practice here, at least my practice on 23Fs, is I file the same day that the petition is filed. As soon as a docket number is assigned, I'll file the brief on it within an hour. Just because there is no time frame set. The second thing is, if you're going to settle the case, tell me. We had a case recently where I wrote a brief and they had settled it and there was nothing on the docket. No one told us. Provide all the necessary information, especially, for example, in the Ninth Circuit. Provide me the excerpts of record as soon as possible, or the record of appeal in another circuit court. Providing that information is critical to drafting the brief. Also being responsive, as Lindsay mentioned. If I have a question, respond. We always share our drafts with counsel to see if they have any comments, especially on the facts. Hey, you got this fact wrong, or you have this wrong. There are some counsel that just don't respond. And so it's okay, well, we're filing, and if we have a fact wrong, so be it. But just being responsive there as well. So mainly just good communication.
Thank you. Judge Katsas, let's talk about reviewing amicus briefs. Do you always read all the amicus briefs, or do you have a clerk take a first pass, select some that maybe that you might prioritize? How does that work in your chambers?
Or my clerks take a first pass on everything. First document I read when I start prepping a case is a bench memo prepared by a clerk, which I use to learn the case. I will carefully read all the party briefs. Part of what the clerk tells me is a top-line assessment of whether amicus briefs add anything new. The ones that have something distinctive and interesting to say, I will read late in the process, but I will read those. The ones that are not helpful, I will just quickly skim to confirm that I don't think they're adding anything.
And one of our panelists asked me to ask you font size and font type. What do you think? What kind of type do you like?
I have no idea. I think our rules address that, but
you don't have any particular preference.
I'm not an expert on that. I know we have 14. We have a rule of 14 point for briefs. That's about all I can tell you. Some of my colleagues are fussy about things like that. But
Jennifer, just step us through the process once you decided to to write the brief, how does that work in your office? Do you have reviewers? Does it go up? How does it work at the EEOC?
Yeah, once the commission authorizes, the attorney writes, an assistant general counsel is the main reviewer. I read it very carefully, and our general counsel, it is going to vary to some extent based on who's sitting in that chair. It's a political position, although right now we have an acting career person. Some general counsels, review things very, very closely. Some, once they've reviewed the recommendation, don't read it as closely. So it's a little bit, that process is a bit easier. The commission typically does not review our briefs. I mean, they don't, sometimes they'll ask to see pieces of it if it's a controversial issue or novel issue, but for the most part, it stays within the Office of General Counsel. And I reluctantly have had to give up insisting on Garamond after the DC Circuit said it didn't like Garamond. So Judge Katsas may not be.
Some of my colleagues are fussy.
Some of my colleagues are too, but so it goes.
John, from your perspective, having written the number of amicus briefs that you have, what are the three things that make an amicus brief from where you sit the most persuasive?
I think first is the identity of both the amicus and the counsel writing the brief. I think that there are some organizations or individuals that their briefs just don't carry any weight. And so writing for those organizations or associating with those counsel just doesn't get you anywhere. So good amicus brief has a reputable organization and reputable counsel on the cover. The second is a unique perspective. Again, the Me Too briefs really don't get you anywhere unless you're really building out an argument that is undercovered in the party's brief. Have a unique perspective. And the third is for the brief to be well written, and that includes being concise. My goal always, and at least in the federal courts of appeal, is somewhere between 4,000 and 4,500 words. I think that's a good length where we can cover an issue in some depth, but not have it so that the law clerks are reading stacks and stacks of briefs. Now, there are some cases where I have hit the word limit, either 6,750 or 7,000. But those are few and far between.
You were a law clerk, John. From your perspective, being a law clerk, which amicus briefs that you read were the most persuasive and helpful to you in your position as a law clerk?
Providing me information that just appears nowhere in the party's briefs or the record. There was one case in particular where I'm not a farming expert, but there was a farming organization that filed a 49-page amicus brief that gave me all this background on the state of farming laws in the jurisdiction and all these different farming techniques. And it really helped me grasp the statute that we were interpreting for the first time. And also kind of just the process that these farms were using. So I am quite confident that the opinion that went out in that case was much better because of that amicus brief, because I don't think any of the law clerks involved in the case or any of the judges that were on the panel had that much information about farming, and the parties just didn't have room in their briefs to provide it.
Thank you. Judge Katsas, oral argument. Under what circumstances will amici be given an opportunity to argue during oral argument?
That's more rare. I think we would almost always grant a motion from the federal government. We would very likely grant a motion from states if we have states as amici. Probably more rare for private party amicus, but not unheard of. Depends on the case too. I mean, Chambers was a good example of a case where we had a ton of amicus argument. Federal government was in it on one side. We had to appoint an amicus to defend our precedent because no one was doing that. And I think we had a third amicus arguing that one, but mostly government parties will grant amicus too.
Thank you. We are ready for final thoughts. I am going to start with you, Lindsay. Final thoughts for us.
I think that the practice of writing amicus briefs is a really important part of our advocacy. And so we are, often looking for firms to partner with. So if there are folks out there who are interested in writing, please consider it. It can be a really rewarding and fantastic part of our advocacy. One practice pointer that I will give, only because I feel like it hasn't come up yet, is as an amicus, I encourage you in the first page of your brief to say what part of the opinion you're responding to and why you are writing separately as amici, and what your brief is about. So very succinctly, as early in the brief as possible, because in many of these cases, there are a multitude of issues up on appeal. And if we are doing our jobs and zeroing in on one piece that's really core to our work and our expertise, we want to let the court know what that's going to be. They're still not mind readers. Set out your statement of interest and your statement of your argument as clearly and early as possible to give that roadmap. And good luck and have fun.
Lindsay, thank you. John?
I think that those that are looking to get amicus support, I would encourage you to have what's been termed now as an amicus wrangler, somebody who is in charge of coordinating all the amicus briefs, of contacting them, and of being the main point of communication, just because it makes it easier for you and for the amici that are filing in the case, and helps also with the amici coordinate amongst themselves if there's one point of contact for the firm.
John, thank you. Jennifer?
Yeah, I actually don't have that much to add. Let us know. We're not really once we hear about it, we're kind of gonna work on our own. We're a little different. We're probably not gonna coordinate other than to find out nuts and bolts about what you're arguing and what your deadlines are. But as I said, I think we have filed in our history as an agency like 1,500 amicus briefs in the Court of Appeals and District Court. So it's a really important part of our program, of our agency's work.
Thank you. Judge Katsas?
I'll just repeat a point I made earlier, which is the briefs that are likely to be helpful to us are probably going to be short, focused, and adding some specific point that the parties haven't fully developed.
Thank you. And now to our co-sponsors. Jonathan?
Hi, everyone. I would just say what a great program and panelists, and I'm happy that we were able to be a part of it and make this available to our members. And we hope that everyone enjoyed the program. We hope to see you at future events. And thank you to the panelists and to MWELA and everyone else for involving us.
Thank you. Rosie?
Well, thank you so much for all the panelists. This was a fantastic and very informative event. And I will give one last plug to when you renew your DC bar license this spring to join the labor and employment law community. We look forward to having some new community members this fall.
Thank you to Judge Katsas, to Jennifer Goldstein, to John Masslon, Lindsay, Nako for participating in today's program. A special thanks to Andrew Adelman, who organized this webinar for us. A final thank you to Rosie Romano and Jonathan Lasken and our co-sponsors for today's program, the DC Bar Labor and Employment Community and the Federal Bar Association DC chapter for future programming from the Metropolitan Washington Employment Lawyers Association. You can find us at www.mwela.org. Thanks for joining us today.